We call him, it's on the bench.
Yes, thank you.
And I wish to deal with Mr. Zuma's contentions concerning Mr. Pietermaritzburg's June 2005 decision to prosecute Mr. Zuma. Our first point is the court dealt extensively in the judgment at paragraphs 134 to 140 with Mr. Zuma's allegations concerning that decision, especially the following two arguments, which were his main arguments. Firstly, that there were no special circumstances and no new evidence justifying Mr. Pietermaritzburg's decision to reverse Mr. Nuka's decision not to prosecute Mr. Zuma. And secondly, that Mr. Pietermaritzburg had taken his decision precipitously, in other words, before the DSO had completed the sensitive further investigation, which the prosecution team had indicated was still necessary, searches and seizures. We submit that on the evidence before this court, there is no prospect of an appeal court overturning this court's findings in paragraphs 131 and 132, which are based on the uncontested evidence of Mr. Pietermaritzburg. And they are namely that he took this decision, that's the one to institute the prosecution against Mr. Zuma, because based on his assessment of the admissible evidence, he concluded there was a reasonable prospect of a successful prosecution. And secondly, that he took a considered decision not to delay announcing his decision until the DSO had completed the search and seizure operations, and his reasons for not delaying the announcement are set out in full in the judgment in paragraph 140. In any event, and this we submit is the important point as far as Mr. Pietermaritzburg is concerned, his decision to prosecute Mr. Zuma is not the operative decision. Consequently, we submit Mr. Pietermaritzburg's alleged misconduct, even if proven, which it was not, is irrelevant. And the reasons for that are, as this court pointed out in the judgment at paragraph 66, when Justice Msimang struck the matter from the roll in September 2006, the effect of that order was to terminate the criminal proceedings against Mr. Zuma and Thales, which Mr. Pietermaritzburg had instituted during 2005. What then happened was, in late 2007, the state commenced fresh criminal proceedings against Mr. Zuma and Thales. The formal act initiating those proceedings were the service on the 28th of December 2007 of the summonses and the indictment on them. Those are matters recounted by this court in its judgment at paragraph 75. And lastly, on this score, as the court pointed out in its judgment at paragraph 100, when in October 2017, in the spy tapes matter, the SCA upheld the challenge to Mr. Mshe's April 2009 decision to withdraw that prosecution, in other words, the late 2007 prosecution against Mr. Zuma. The legal effect of that was that the prosecution, which Mr. Mshe and his team had instituted in late 2007, was revived. So the prosecution which is currently of Mr. Zuma, as distinct from the prosecution of Thales, which was not affected directly by that order, is the one ensuing from the decision taken in late 2007 by Mr. Mshe in conjunction with the prosecution team and the senior leadership of the NPA. That's the operative decision. And if I may ask the court just to make a mental note of the following, that has a very important implication for my learned friend Mr. Katz's client's first ground of appeal, the one relating to section 179 sub 2 of the Constitution, as we shall see in a moment when I get to that aspect of the case. My learned friend Mr. Sikikani indicated that that his side do not abandon Mr. Zuma's contentions relating to the Browse Mole investigation. Now, I shall be very brief there. Firstly, because this court dealt extensively in the judgment at paragraphs 146 to 148 with those allegations. Secondly, on the evidence we submit there is no prospect of an appeal court overturning the following key findings of this court at that part, specifically 147 to 148. The first is that the Browse Mole report had nothing to do with and played no part in the investigation and prosecution of Mr. Zuma and Thales. And indeed, it was not something which was made available even to the prosecution team, and you have uncontested evidence from the leader of the prosecution team and the leader of the investigation team, Messrs. Downer and Deploy, as the court mentioned in its judgment. Secondly, and consequently, as the High Court and the SCA found in the spy tapes matter, and this court affirmed, these allegations concerning the Browse-Mail report are simply diversionary and irrelevant. That brings me to what appeared to be the mainstay of the factual mainstay of the argument addressed to this court this morning on Mr. Zuma's behalf, and that concerns Mr. McCarthy's discussion with Mr. Nmuka in late 2007. Now we wish to make two preliminary observations. It appears from the written submissions and from the notice of application for leave to appeal that considerable reliance in this context is placed on two documents. The first is the findings of political interference by Justice Nicholson in the case concerning section 179 sub 5D of the Constitution. Now the thing is, not only was that judgment reversed on appeal, but as this court noted in the judgment at paragraph 78, in its judgment in that matter, that's the 2009 volume 2 SA 277 SCA judgment of Hurrams DP for the SCA, the court strongly criticized Justice Nicholson for making the findings of political interference that he did, and it went on to hold that the allegations by Mr. Zuma on which those findings were based were irrelevant, gratuitous, based on suspicion and not on fact, and felt to be struck out with a punitive costs order. So,
But I think, Mr. Pietermaritzburg, the argument really is that another court may look at the constitutional violation and don't go further than that and say, but look, we find that there was these constitutional violations, and as a result, we don't have to go further and decide whether they compromise the integrity of the investigation and prosecution.
I understand that, and the method that I've adopted in addressing that general, I could say, conclusionary submission is to look as briefly as possible at the factual underpinnings of that. We've gone through Mr. Nmuka's decision, Mr. Pikoli's decision, and now we're dealing with the conversations by Mr. McCarthy with Mr. Nmuka. Because at the end of the day, there's a premise, a big premise in the argument, the general argument which has been advanced, and that is that there are indeed constitutional violations. And I shall deal in a moment with the merits, if I can call it that, of this particular contention. The preliminary point which I'm making, though, is that there's been repeated urgings in the main case and again today that another court may look at things differently because of what Justice Nicholson said. With respect to Justice Nicholson, everything that he said was overruled. It's not just as if his order was overruled. His reasoning and analysis on this matter was strongly criticized, and this court, with respect, correctly said so in its judgment. And the same applies to the second document upon which the first accused team rely, and that is the answering affidavit made for the NPA in the spy tapes matter by Mr. Hofmeyer. Now we know that that affidavit, with reference to these conversations specifically, made out a case that Mr. Mshe was justified, fully justified in terminating the prosecution. But as this court has noted, that affidavit was trenchantly criticized by the SCA in the ensuing appeal, and the relevant parts of the appeal are in fact set out in Mr. Downer's affidavit in the recorded volume 10, page 2926, paragraph 539. It's a paragraph which spans several pages, and with respect, it does not assist to rely on an affidavit which has been found to be fundamentally flawed. The deponent has been described as straining to justify an irrational decision by the SCA in relation to this matter.
But then the argument was that that was in a different context. So we should look at it in the context of the permanent stay, together with the violations, the constitutional violations on Mr. Zuma.
I understand the arguments, and our response to that is twofold. The first is the issue estoppel point. So this point was raised in litigation involving the DA, Mr. Zuma, and the NPA, being the spy tapes litigation. It was exhaustively, it was discussed by the SCA in that case, and a finding was made which, with respect, is binding on Mr. Zuma on this question. And I consequently most respectfully submit that there is no prospect whatsoever of the SCA itself, or any other appeal court for that matter, interfering with the finding in paragraph 144 of this court's judgment, that because he was a party to the DA review applications, the findings of the SCA on the spy tapes issue are binding on him. That's the first answer that we have. Secondly, though, this court did not stop there. It examined the evidence, the full evidence in connection with this, that was in the record before it, and as explained in the immediately preceding paragraph 143 of its judgment, the court held that the recordings of the telephone calls between Mr. McCarthy and Mr. Zuma were about the timing of the service of the indictment, and even if taken at face value, they didn't impinge on the propriety of the investigation of the case against Mr. Zuma or the merits of the prosecution itself. And the reason is obvious. There is no evidence that any member of the investigation or prosecution team was aware of, let alone involved in Mr. McCarthy's discussions with Mr. Nuka. Consequently, as this court found with respect in an unanswerable conclusion, there is no evidence that the decision that was taken in 2007 to reinstitute the prosecution against Mr. Zuma and Charles was based on political considerations. So the argument which has been addressed to the court with respect puts the cart in front of the horse. You've heard a lot about political considerations playing a role, constitutional violations, violations of the law. What the court grappled with in its judgment, in extenso, were the factual underpinnings for that. And the problem with this application, which is ultimately, as we shall be submitting, is a hopeless application, is that on examination, firstly, the court engaged with the factual underpinnings. Secondly, on the evidence before the court, there is no prospect whatsoever of an appeal court coming to a different conclusion. For instance, in relation to this, the court knows there is extensive evidence in the papers before it, and I refer particularly to Mr. Downer's affidavit in volume 10, page 2820, paragraphs 299 to 314, setting out a series of engagements between the prosecution team and the senior leadership of the NPA. That included a formal application to the acting NDPP of the time, Mr. Mshe, for approval for the inclusion of racketeering charges in the indictment. And we know that that resulted in a decision in principle taken in late November 2007, based on an assessment of the available evidence and the state's readiness to proceed in the light of the SCA judgments upholding its appeal in the search warrant matters. That decision was that the prosecution should be reinstituted and that the indictment should include racketeering charges. The striking feature of this case is that in order to meet Mr. Zuma's allegations of political interference, what the state has done is it has discovered all of the contemporaneous documents. They were given to Mr. Zuma before he filed his supplementary affidavit, and the papers, as the court know, include a hundreds-page affidavit, a very large portion of which comprises a chronology substantiated by the relevant documents, including the application, the racketeering application to which I've just referred. But there's a further problem for Mr. Zuma, and it's this. When Mr. Mshe came to announce his decision, in 2009 that he was regretfully going to terminate the prosecution because of this very matter that I'm addressing the court on at the moment, Mr. McCarthy's conversations with Mr. Nnuka. Mr. Mshe was at pains to make it clear that the MPA had found nothing relating to, and I quote, the substantive merits which militated against the continuation of the prosecution. And that's in Mr. Mshe's media statement of the 6th of April 2009, which is in volume 14 of the record at page 4145. It's Annexure NPA 84. And this was a point emphasized by the SCA in the spy attempts case. This was a decision taken in the teeth of evidence showing that the NPA had a strong case against Mr. Zuma, and despite it, which is why Mr. Mshe described it in the way that he did. So returning to what this court found, is there any evidence that these conversations impinged on the propriety of the investigation of the case against Mr. Zuma or on the merits of the prosecution itself? None whatsoever. Now this is the mainstay of the case presented today. It is these two fundamental problems: a complete absence of any evidence and a finding by the SCA in litigation involving the same parties which focused on this issue and this issue alone, adverse to Mr. Zuma. It is inconceivable that the SCA will come to a different conclusion. It will apply issue estoppel, and in any event, the evidence before this court and the evidence before it on the previous occasion point in one direction only. That then brings me to Mr. Zuma's contentions concerning the responsibility for the delay. Now, the first point that we wish to make is that in the judgment, the portion of the judgment in question, which is paragraph 65 and 66, the court's finding in this connection is rather confined with respect. It concerns the period between Mr. Zuma's challenge to the 2005 searches, which happened in August 2005, and the end of the litigation in connection with them in the Constitutional Court in July 2008. And it was in relation to that period alone that this court made the finding, which is now the focus of this ground of the application for leave to appeal. Now, the first point that we wish to make is similar to the one which we made in respect of Mr. Justice Nicholson's judgment, but of different character. We know that in this connection, Mr. Zuma relies heavily, as he did in the main argument, on for these allegations on the findings of Justice Msimang, adverse to the MPA, in the application for a postponement which the state brought in mid-2006, based on the fact that it wasn't ready because of this litigation about the search warrants. The court referred to those the findings in its judgment in paragraph 65 and 66. Interestingly, and the court will have picked up by now, one of the central themes of the submissions that we are making today is that there are many allegations, particularly in the notice of application for leave to appeal, that the court didn't consider this or didn't consider that. But when one reads the very extensive judgment of the court, for instance, these findings are recounted, that there was a very, that he was scathing in his criticism of the state's decision to proceed with the stage when the searches had not been concluded. Now, those proceedings are interlocutory proceedings, and consequently, they are not binding on this court or any other court. Secondly, in paragraph 141 of its judgment, this court made the finding to which Mr. Zuma has taken exception in his notice of application for leave to appeal, namely that the state and Mr. Zuma are equally liable for the delay between the execution of the warrants in August 2005 and the final judgment of the Constitutional Court in the ensuing legal challenges by him, Thales, and his attorney, Mr. Halley, in July 2008. We submit there is no prospect of a court finding that the state was solely responsible for the delay, and our submission on this in this regard is consonant with what the court said in its judgment on this aspect. Mr. Zuma had an election. He was within his rights to institute pre-trial proceedings challenging the warrants and the ensuing searches. But he could equally have waited until the trial to challenge the admissibility of the material seized during those searches. Had he done the latter, there would have been no delay. And the basic and obvious point that the court was making is that having elected to opt for the pre-trial litigation, which led to a delay, he was co-responsible with the state, which had undertaken the searches for the time that was taken in dealing with those challenges. It is not a big point held against him, but equally there is no prospect of any court looking objectively and rationally at this matter, concluding that the state was solely to blame for the delay in that connection, because he could have dealt with things differently. There was some mention in oral argument today to the delay following the ill-fated decision of Mr. Mshe's in 2009, April 2009. Now, as regards that, as the court knows, we submitted, and this is not a matter dealt with in the court's judgment, and indeed this particular complaint I've not been able to locate in the notice of application for leave to appeal, but it was advanced, and so I shall deal with it briefly nevertheless. Mr. Zuma stood shoulder to shoulder with the NPA in defending Mr. Mshe's decision over a period of 8 years. 8 and a bit years, 8 and a half, from April 2009 until October 2017. Secondly, at one stage, he even went so far as to pursue an appeal in the SCA alone, in other words, without the NPA, on an interlocutory ruling concerning the composition of the review record. That judgment is reported. It's Zuma versus the DA and others. It's in the All South Africa reports at volume 2014, volume 4, at page 35. And the court will also know that much of the trouble in that case, or much of the delay, arose from his refusal to give permission for the record to include, amongst other things, his representations and material related to the submissions that had been made on the spy tapes. So the case was about the spy tapes because that's what Mr. Mshe had relied on, but Mr. Zuma opposed the inclusion of that material in the record. That caused the state attorney not to provide it, and it went 2 rounds on that matter. In the second of those, Mr. Zuma alone, and it took up another year or 2 of that time. So insofar as there's a suggestion that he's not in any way to be held responsible for that period, we respectfully submit that doesn't hold water. We accept, obviously, that the NPA was the primary cause of that delay because it was Mr. Mshe's incorrect decision which caused matters to grind to a halt. But it was one favourable to Mr. Zuma, and it was one that he defended tooth and nail until ultimately, together with the NPA, the appeal was conceded in September 2017. That then brings me to the last of Mr. Zuma's contentions on the merits, and it is it concerns paragraph 150 of the judgment, much discussed, namely the court's finding that the seriousness of the offences that Mr. Zuma is facing outweighs any prejudice which he claims he will suffer if the trial proceeds. Our submissions on this are firstly that the court cannot be faulted either on the law or the facts for making the finding. And indeed I understood my learned friend this morning to make a concession that as regards the law, which this court surveyed at length in its judgment at paragraphs 116 to 125, went through the most important cases, both pre and post the commencement of the Constitution. What this court pointed out, with respect correctly, that is what is required in every case is a balancing of the relevant factors. Now the factors to be balanced include, obviously, on the side of the applicant for the stay of prosecution, any prejudice that has been suffered or will be suffered if the accused is tried after the elapse of a reasonable time. One factor mentioned in the much discussed paragraph 150. On the other side of the scale, there is the nature and the seriousness of the offence. That is referred to, amongst others, in Botma and else, at great length, a case in which a very lengthy delay was justified inter alia on the nature and seriousness of the offence, and indeed it was in that case that the SCA emphasised the importance of that weighing in the scales. So on the law, this court cannot be faulted. It was following a well-trodden, with respect, path, that matter, Zanna's case and Sanderson's matter, as to what the law is. So legally, this aspect of the intended appeal is on a very shaky foundation. It was conceded also, if I understood my learned friend correctly, that the offences with which Mr. Zuma is charged are indeed very serious, involving, as they do, the alleged corruption of someone who at the time was the second most senior member of the National Executive. That then brings us to the prejudice which Mr. Zuma says he will suffer if the trial proceeds. And if we understood the argument, particularly in the heads of argument, and I'm referring to the heads at page 30, paragraph 66, and the heads at page 31, paragraph 69, is his claim, with which I've already dealt, that the findings in the Sheikh criminal trial and the ensuing appeals mean, and I quote, that Mr. Zuma has little, if any, scope to challenge the evidence which was led and which implicated him. And secondly, the trial court would not be able to ignore the conclusions of wrongdoing that Mr. Sheikh was convicted of. As I've already stated or submitted, both of those contentions are manifestly incorrect. He will be entitled to challenge all the evidence for the state at his trial. The factual findings of the courts in the Sheikh criminal matter constitute the opinions of other courts. They will neither be relevant nor admissible against him. That then brings me, so our conclusionary submission then is that Mr. Zuma has not demonstrated reasonable prospects of success in the legally relevant sense, namely a sound, rational basis showing he has a realistic chance of meeting the very high standard for an application for a stay of prosecution based on prejudice that isn't trial-related. His trial-related prejudice is utterly without foundation. He has another string to his bow, and it is section 17(1)(a)(2), and specifically the provision in effect in that the statement in that provision that leave may be granted even if the judges do not believe that the appeal would have a reasonable prospect of success, if there is some other compelling reason why the appeal should not be heard. Now, if one has regard to the heads of argument filed by Mr. Zuma at page 19, paragraph 33, I submit it is fair to say that in effect his contention in this connection is that the court should, regardless of an adverse finding to him on reasonable prospects if one is made, grant him leave to appeal to the SCA because his application for a permanent stay and his prosecution are important. He says this is an important case. And secondly, he says his case deals with an important question of law. Now, as far as the importance of the case is concerned, it is undoubtedly an important case in the overall context. It's one which has enjoyed wide attention. But the real importance, we submit, is that, as this court indicated, this case paves the way for him to have his day in court. So the really important case is not this case about whether there should be a case, but the criminal trial. And our legal policy is very clear. This preemptive remedy of a permanent stay of prosecution, stopping a trial before it starts, not allowing the state to present its case against an accused, is an exceptional and extraordinary one. And one only has to think of the case in that way, and that's what Judge Kriegler said in Sanderson, to realize that there's some other compelling reason for yet further delay, which is what will inevitably ensue if leave to appeal. It really has to be very compelling indeed. The example which is given in section 17(1)(a)(2) is if there are conflicting judgments in high courts. And it's something as of that ilk, I would submit, eius tem generis. There has to be something truly extraordinary as to make an appeal compelling, even though there are no reasonable prospects of success. And for the most part, that will be cases where there's a legal problem of general application which needs to be cleared up by a court whose decisions are binding in the whole country.
Isn't this issue about the SCA having pronounced on various other aspects except for the context of the permanent stay? For instance, on the Hofmeyr affidavit, that it was dealt with in that context of that review, and now when it comes to this application, it might view it differently, and also the trial run.
The dry run.
The dry run, yes, the dry run. That other conclusions have already been made. For instance, the encrypted fix. That might be an issue that warrants their attention.
I would respectfully answer that as follows. The points just made take me back into 2 or 3 of the merits points. Now, if the court has held that they are without merit and they do not meet the required standard, then one cannot reuse them to show compelling reasons because they are ultimately fact dependent. There's a second and perhaps related point, certainly related in the way in which this court dealt with the big point, which has to be the big point because it attacks Mr. Mshe's decision, which is the operative one, and it's the spy tapes point. The SCA has already spoken on that topic. This court has held that Mr. Zuma's issue is stopped, with respect quite correctly so. So it would certainly not be a compelling reason for a matter on which this court has correctly held that the intended appellant is issue stopped to allow the appeal to go ahead. For the SCA simply to say, well, I've already dealt with this issue.
No, I think the really issue is whether they haven't been given an opportunity to deal with that issue in the context of the permanent stay. That's it.
And
Yes.
and what I would respectfully suggest in that connection is for your consideration is the following. They have had the fullest opportunity in this litigation. The papers are very voluminous indeed. The founding papers run to thousands of pages. The 4 days was spent in argument before a court constituted by 3 judges and gave anxious and full consideration to the points made. Ultimately, this case, Mr. Zuma's case, is not about new law. As the Ladyship Justice Steyn pointed out to me on the last occasion when I tried to rehearse the principles, the court knows the law and has written previously on the matter, and it has recapped the law here. It's a case about the facts. And if the facts have been found emphatically, as this court has found, to a point away from the contentions raised, we really are reduced to the standard set by the SCA, and it's the only question in this case, in my respectful submission, and that is there a sound, rational basis to conclude that there is a reasonable prospect of success? Because it doesn't raise an important legal question or something else. The importance overall of this case lies in the fact that the prosecution must now start without delay. The Judge President of this court, in constituting of this division, in constituting this court, has given this case the attention it deserves. If a judgment such as the one that this court has delivered, which cannot rationally and on a sound basis be attacked on its merits, has been given, the matter must stop here, and Mr. Zuma must have his day in court. So the compelling reason, if there are any compelling reasons, because this case is about delay, for that reason alone, militates against allowing an appeal. But there is another reason which we submit the court should take into consideration, and it's this. I mentioned at the outset that these two appellants are intending to follow different routes. Mr. Zuma's legal team have said, and an affidavit was filed yesterday confirming this, they've informed the Judge President that if leave to appeal is refused, they will be applying for leave to appeal to the SCA, and if that is refused, or if appeal is granted and the appeal is unsuccessful, they're going to go to the Constitutional Court. The Supreme Court of Appeal on 2 occasions has dealt with the prosecution or matters concerning the prosecution of Mr. Zuma, the one instituted in 2007. It did so in the appeal against Justice Nicholson's judgment, in the judgment handed down at the beginning of 2009, and it did so again in 2018. In fact, the judgment was handed down in October 2017, but it's reported in early 2018. And a striking feature about the argument which the court has heard in this matter, and indeed about many grounds of appeal, is that they traverse matters which were decided by the SCA. So, for instance, you are urged to hold that Justice Harams was wrong to say that where there is probable cause to prosecute, a bad motive doesn't invalidate the decision. So that's an issue which has already been dealt with by the SCA.
But the issue of the approach to be followed when you're confronted with that situation, we don't have a direction on that.
Mark, on that particular issue.
Yes.
So the interesting thing about that point is that it falls again into, with what is respect, the general submissions that have been made. And the reason for that is the following. You'll recall my submission that there is no evidence of political interference and that this court will undoubtedly not be overturned on that. That's where the whole motive thing comes in. So in other words, to get into an argument in the SCA a second time about whether Justice Harams was right, they first have to establish on the fact that there was a bad motive, an improper purpose. But they don't get out of the starting blocks. Many of the arguments addressed to the court at a level intended to tantalize the court into thinking that their interesting legal questions lack the factual underpinnings to get there. And we'll see the same, unfortunately, besets Mr. Katz's submissions with respect in relation to aspects of tolerance. Similarly, let's just stick with this spy tapes thing. So what's it seriously intended here? And this is not an argument advanced, a compelling reason. There's a compelling reason to go back to the SCA to deal with spy tapes yet again. There can't be. If one takes an overview of this case, I won't say an appeal to the SCA will be a waste of time, but the SCA has already grappled with much of what has been submitted to you. Political interference in relation to the 2007 decision in particular. And it's done so twice.
In another context, that was the submission.
But the facts are the same. One just has to read the judgment of Justice Nafsa. Read the application for leave to appeal judgment. I'm speaking to myself saying read it with respect. In 2016 in the High Court in that matter. There's an American film called Groundhog Day. It drives me mad. It's this thing about something which recurs and recurs and recurs again. If there is to be an appeal, and we submit there is, on the reasonable prospects of success, there oughtn't to be one. There is a very good reason tied up firstly with time is of the essence, and secondly with the fact that the SCA has spoken on so many of the important issues in this case already for going the route which Thales have gone. It makes sense. We've opposed that application on its merits as we oppose this one on its merits. We put up a stout fight on the interlocutory nature of the stay of prosecution application in connection with trial-related prejudice, and they've conceded that. So that is an issue which can and must be dealt with at the trial, but for the rest we are opposing that. And we will obviously oppose Mr. Zuma if he does the same. But it really would not be in the interest of justice, firstly, for these two appeals to diverge, one to go to the SCA and the other one to go to the Constitutional Court, and that's simply because Mr. Zuma has not joined the Charlies in making a conditional application to the Constitutional Court. As we all know, that the Constitutional Court is very averse to taking direct appeals. There have to be exceptional circumstances. The court has before it the correspondence addressed to Mr. Zuma explaining why in the state's position estimation there are such circumstances in this case. Mr. Zuma's response was to reject the invitation and the state's accompanying consent to the extension of the time periods, which obviously is not binding on the Chief Justice of the Constitutional Court, saying in effect that the state is seeking to dictate to him the route that he should follow. With respect, the state is not dictating anything. It is simply saying that a submission that there is another compelling reason for an appeal to go to the SCA is undermined by his insistence on going via Bloemfontein if appeal is granted. And I have to say in this connection, what is very concerning to my client, the state, is this. The impression, unfortunate impression created by all of this, that it's about delaying his day in court, his ultimate day in court. It's about Stalingrad. That then brings me to the submission that the court should not have made a costs order against him. Now, the first point we wish to make in that connection, that this point which is raised in the heads of argument at page 54, paragraph 129, and also Weighty and Mr. Manch's affidavit that was filed together with the heads of argument, is not raised in the application for leave to appeal.
You keep referring to Mr. Manch's affidavit, but we don't have that.
We don't have such an affidavit.
I was handed, or it was transmitted to me, an affidavit was served on my attorneys yesterday. First accused affidavit in response to Diana's answering affidavit.
No, we don't have that.
Perhaps those are proceeding in the CC or
No, it was filed in this court.
for us. No, we don't have that.
You don't have that affidavit.
Sorry, when was it filed?
Yesterday,
Any
together with the
time?
heads of argument. It was served. I cannot say whether it was filed. I'm sorry, I assumed it had been filed. I won't refer to the affidavit if it hasn't been.
No,
No, it's not been, so you need not.
So in the heads of argument at page 54, paragraph 129, this point is raised. But it is not raised in the application for leave to appeal. And an interesting feature, like the jurisdiction point to which I'm going to refer briefly in a moment, it wasn't raised in the proceedings before this court either. So the first time that we became aware of this complaint about the court's judgment was when we read the heads of arguments and in connection with a matter which in fairness was not put to the court. It was not argued. The case was dealt with on the basis that costs would follow the result on both sides, and that was that. Now a point is taken that this court oughtn't to have granted a costs order. Our first point is that the point cannot be taken without it being taken in the notice of application for leave to appeal. And even if it had been taken in the notice of application for leave to appeal, my learned friends or their client would owe the court an explanation as to why the point wasn't taken when the matter was argued.
Well, if I remember correctly, they asked for costs
Yes,
if the application was going to be in their favor.
yes.
But
Both sides approached the matter on that basis.
Yes.
But also, Mr. Redebach, we consider what the grounds of appeal was that was filed here at court. I mean, those are the grounds.
That's correct.
Yes.
Insofar as the court wishes to consider the merits of this, we do accept the Sardisan judgment. I've read the paragraph. I must say I'd overlooked it at the time, paragraph 44. It says, ordinarily the dismissal of an application for a permanent stay of prosecution shouldn't carry an adverse costs order, and that's because the application relates to criminal proceedings which are instituted by the state and in which costs orders are not competent. But the court goes on to say costs may be awarded in effect where the applicant doesn't raise a genuine complaint on a point of substance. Now, the first submission we make is that the court examined all of Mr. Zuma's complaints in great detail in its judgment, and as its judgment makes clear, none of them are points of substance. The second is, we persist with our submission that having regard to what was said to the SCA in September 2017, when, having conceded the appeal, counsel immediately said Mr. Zuma reserves his rights to take all the steps open to him. He has every intention in the future to continue to use such processes as are available to him to resist prosecution. That is code for Stalingrad. That is what has been happening in this matter over a period of some years. And we will go so far as to submit that this application for leave to appeal, with the intended route to Bloemfontein and then on to Johannesburg, is again a thread running through this is about time. It's about delay. It's the supreme irony of this particular litigation. The complaint is delay, but the conduct of the litigant is conducive to delay. So with respect, we submit that these complaints, dressed up as they are, as constitutional violations, etc., they are not genuine complaints, because when one drills down to the underlying facts, they are like candy floss. One grabs it and there's nothing there. And oftentimes there's already a decision adverse to the client by a higher court. I would then wish to deal very briefly with this question of jurisdiction. And I might do so mindfully of the discussion.
But you had to, because Mr. Sikakane said that is not for us to deal with, because he conceded.
It was never an issue before.
And it was never an issue before us.
I've asked him about that.
So I would just wish to clarify one thing through the court with my learned friends.
Yes.
I understood him to say they do intend arguing it on the appeal if an appeal is granted.
Yes.
And if I understood them correctly, that's what they say. And I make the following submissions with the greatest respect to the court. If an applicant, as this applicant has done, takes a point as an intended ground of repeal, which is that the court lacks jurisdiction, then the court's duty under section 17(1)(a) is to evaluate that ground and all other grounds of appeal for reasonable prospects of success. The court is entitled, indeed more than entitled, to feel aggrieved that the point was not raised, as fundamental a point as this one was not raised before it. Yes, certain things were noted in pre-trial proceedings, but when the matter came to be argued in this court, it was not raised. The court is consequently at a disadvantage, but it is a disadvantage of Mr. Zuma's making, not of its own making. What the court is now told is that, yes, we did not take this point. We intend, if leave to appeal is granted, contending in the SCA that we lack jurisdiction in the piece altogether. Our most respectful submission is that Mr. Sikakane's suggestion, beguiling as it is, should not be accepted. And the reason...
Well, if for instance, you look at Section 14 of the Superior Court Act, it caters for these situations. So I don't think that it was not properly before us. It was never raised. And in any event, if you look at the powers of the Judge President, or Senior Judge for that matter, those are set out in Section 14 of the Superior Court Act.
So with respect, I agree with your Lordship. I just wish to then very, very briefly address the merits of this. I urge the court to deal with it on its merits. I respectfully submit it's the duty of the court to do so, even though it's raised belatedly in this fashion. Our submissions briefly are the following. It hinges on section 145(1)(a) of the Criminal Procedure Act. The contention is that only a court constituted as a criminal trial court in terms of that section could validly determine his application for a permanent stay of prosecution. But as her ladyship indicated in the debate with my learned friend today, the Criminal Procedure Act says when a trial starts, and section 105 is the key provision. It says the charge shall be put to the accused by the prosecutor before the trial of the accused is commenced, and the accused shall be required by the court forthwith to plead thereto in accordance with section 106. And then in a matter called Mamase, it's in the bundle at page 87, at paragraph 6, the SCA said The plea is the procedure that initiates the trial and serves to define the issues that are submitted to the court for adjudication. The trial then commences with the evidence. So before the charges are put to the accused and he's asked to plead and does so, there is no trial. We are in a pre-trial proceeding, and consequently section 1451A, which says that a criminal trial court is a judge sitting with or without assessors. That's the court which is constituted when Mr. Zuma is now going to be called on to plead and the trial to start. His Lordship refers, we know that Mr. Zuma hasn't been called on to do that. His Lordship refers to section 14(1)(a). I have a niggling concern that I have to raise in relation to that with the court, and I just give it to the court for its consideration. That provision refers to civil proceedings, and it may well be that these proceedings are sui generis and not
Yes.
civil proceedings. But that's not the end of the matter. Section 4B of the same Act, the Superior Courts Act, says the management of the judicial functions of each court is the responsibility of the head of the court, and it then goes on to say in section 8(6)(c) what they are, or 8(6) what they are, and one of them, C, is the assignment of cases to judicial officers. And the same is repeated in the norms and standards for judicial officers issued by the Chief Justice. So with respect, the Judge President validly exercised that power in the present case, because we are dealing with a matter where the trial hasn't started. So this point is without merit, and consequently I submit that Mr. Zuma's application for leave to appeal should be dismissed. The only remaining issue is the question of the costs of this application. This is a rather sensitive aspect of the case. Now, I heard my learned friend for Mr. Zuma apologize unreservedly this morning for the insults in the notice of application for leave to appeal. The statements in question are set out in footnote 10 of our heads on page 10. And this matter concerns the court. And the court must obviously take a decision on how to deal with it. It's a matter within its discretion. The court may accept the apology and leave it at that. The court may do so and make a remark in its judgment, should it wish. We most respectfully submit that the apology alone is not sufficient, having regard to what is said, and I do not intend repeating in open court what was said there. But I would make the following point in support of that. It goes to what was said, how it was said, but also it's not the first time that Mr. Zuma in this litigation has made insulting allegations in papers. In 2009, the SCA struck out with the punitive costs orders certain allegations made. This court, ultimately by agreement, struck out scandalous and vexatious matter from his replying affidavit in this matter. It's true that those were directed at officers of the court, prosecutors. But in De Lacy's case, that is 2011 volume 9, BCLR 905 CC at paragraph 117, Moseneki DCJ said punitive costs orders may be made against litigants who make sustained and unwarranted attacks on officers of the court and judicial officers. And we submit that in all the circumstances of this matter, it would not be out of place if this court were to order Mr. Zuma to pay the costs of this application on an attorney and client scale as a mark of its displeasure. That then brings me to Charles's application. Now, this is confined, as the court knows, to the dismissal of the application for judicial review of Mr. Abrams' decision, and we don't contend, as we do not in relation to Mr. Zuma's application based on political interference and the like, that the decision of this court is not appealable. That's confined simply to the trial-related prejudice stay of prosecution grounds, which don't feature at all now in Charles's application. We will address each of Charles's three allegations or grounds of appeal in turn, and I hope to be as brief as possible in this regard. The first, then, is the contention that Mr. Abrams did not have the power to decide to reinstitute the prosecution against it. Now, we've dealt with this issue fully in our heads of argument at pages 38 to 43, paragraph 76 to 88. And in this connection, you will recall I asked the court to make a mental note about what is the operative decision at the moment. So, in relation to Mr. Zuma, the operative decision is the decision taken by Mr. Mshe and his team in late 2007. In relation to Mr. Tutale's, the operative decision is Mr. Abrams' decision announced in March 2018. The interesting thing, though, is that when Mr. Zuma, so when Mr. Mshe had taken and announced that decision, Mr. Zuma attacked it on the grounds that the decision had been taken under section 179(5)(d) of the Constitution, and the provisions of section 179 are at page 3 of our bundle. And consequently, he said he was entitled to make representations as is required by the Constitution whenever a decision is reviewed. Now, in its judgment, this is the judgment by Justice Harams, and specifically I'm not going to take the court to the in detail at paragraphs 57 to 64 of that judgment. The court had a hard look at this contention, and the strongest reason, it said, which militated against it, was that the decision taken by Mr. Mshe and his team in 2007 was not one taken in terms of 179(5)(d), but it was taken in terms of section 179(2). And that is the empowering provision. The court has quoted that passage from the judgment, and in footnote 29 on page 39 of our heads of argument, we quote it again. Section 179(2) is the empowering provision. It empowers the NPA to institute criminal proceedings and to carry out any necessary functions incidental to instituting criminal proceedings. The power to make prosecutorial decisions and to review them flows from this. So if one then thinks back, well, what was happening in 2007? There had been a prosecution instituted by Mr. Pikoli in 2005. The matter was struck from the roll in September 2006 by Justice Sumar, and Mr. Mshe and his team reinstituted the prosecution in 2007. And so consequently, when making this finding, what the SCA was saying is that if you have previously instituted prosecution which is terminated for whatever reason, you being the NDPP, and you reinstitute it, you are doing so under section 179 sub 2 of the Constitution. That is the central finding and the main reason why that application by Mr. Zuma failed on appeal. We are now told that there's a reasonable prospect that the SCA will find that that was wrong. But it has decided the very issue, the reinstitution of a prosecution by the NDPP. And it affirmed that in 2018, or in October 2017, in its judgment in the spy tapes matter. We give the references in paragraph 79. That case had to do with the decision to terminate. And we submit that this finding is in any event obviously correct if one has regard to section 1791 and 1792 and reads them together as one has to. 1791 provides in its relevant parts there is a single national prosecuting authority. Now I wish you just to underline the word national prosecuting authority in the Republic. Structured in terms of an Act of Parliament and consisting of an NDPP, DPPs and prosecutors. That's what 1791 says. There's a national prosecuting authority, and it consists of these people: the NDPP, the DPPs, and prosecutors. 2. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out incidental functions. No wonder Justice Harams made the finding that he did. There's a single national prosecuting authority consisting of the NDPP and others, which has the power to institute criminal proceedings on behalf of the state. So that finding is undoubtedly correct and unassailable. It's in any case a finding by the SCA. It's certainly not a ground for leave to appeal to the SCA. The SCA has already decided the question. Yes, Thales wasn't a party to that, but it's a legal question. But maybe one could try and persuade the Constitutional Court otherwise. That's another matter. But that's the reason why I've made the submission that the findings in any event on its merits obviously are the right one. That then really brings us to an argument about the facts of this case. And there are two relevant sets of facts. The first is what did Mr. Abrams rely on? He relied on section 179.2. We have set that out in paragraphs 82 and 83 of the heads of argument, the contemporaneous correspondence, and in his affidavit. He was very clear about that, and that's not surprising because you'll record the appeal in the SCA was conceded on the basis that Mr. Mshed wrongly thought he was acting under 179.5D in 2009. That was one of the two grounds on which the appeal went the way that it did, the other being rationality. One is then left with the fact that in the NDPP's heads of argument, reference was made to section 22.1, and the court also referred to it of the NPA Act. Now, we deal with that in our heads of argument at page 80, paragraphs 85 and 86. Section 22.1, the NPA Act, the next provision, and 22 is on page 5 of this bundle. That provides the National Director as head of the prosecuting authority shall have authority over the exercising of all powers, the performance of all duties and functions conferred on or imposed or assigned to any member of the prosecuting authority by the Constitution, Act, or any other law. Our submission is that this provision affirms the NDPP's powers to manage and control all members of the NPA. What happened in this case was that Mr. Abrams announced two things. He said firstly that he had declined Mr. Zuma's representations. This was on the 16th of March 2018. And he said secondly he's decided to prosecute Thales, and he went on to say the DPP and KZN would see to the practicalities of the matter, would facilitate the necessary processes for Mr. Zuma and his co-accused to appear in court with the words used. So in giving those directions, he was exercising the general power to manage and control all members of the NPA conferred on him. He was also exercising the incidental power referred to in section 179.2, which is to carry out any necessary functions incidental to the instituting of criminal proceedings, by telling the world that this is what would happen, and we know that as a matter of fact that's what happened. The prosecutor was assigned to the matter, the accused were brought before the court, and there were series and postponements, etc., to allow inter alia for these proceedings. So the real point is that the decision was taken in terms of 179.2. That's what the record shows. That's what the answer is. And there was some case management which is amply justified by Section 22 of the Prosecuting Authority Act. Where does the doctrine of subsidiarity come into it? I was indeed puzzled by this point. And without wishing to belabor it, what I wish to say is, firstly, if one has regard to our heads of argument at page 39, paragraph 39 to 40, it's paragraph 81. The doctrine of subsidiarity is a doctrine of constitutional law, which, in the words of the Constitutional Court, in the My Vote accounts case, and it's at page 142 of the bundle. Sorry, I've got the wrong, it's page 140 of the bundle. Paragraph 53 is to the following effect. So it's towards about an inch or two from the bottom of the page. Justice Cameron speaking for the minority of the CC in that case, but that dictum was confirmed in a matter called Public Servants Association on behalf of Obogu, and the reference is given in footnote 33 of our heads. So this is now a well-established principle, and it is to the following effect. A litigant cannot directly invoke the Constitution to extract a right, I emphasize the word right, he or she seeks to enforce force without first relying on or attacking the constitutionality of legislation enacted to give effect to that right. This is the form of constitutional subsidiarity Parliament invokes here. And then once legislation to fulfill a constitutional right exists, the Constitution's embodiment of that right is no longer the prime mechanism for its enforcement. The legislation is primary. The right in the Constitution plays only a subsidiary or supporting role. So what it means in practical terms is that if a law like PAJA, enacted to give effect to the right to administrative justice in section 33, governs the situation. If you bring a review nowadays, you bring it under PAJA, you don't bring it under section 33, and the Constitutional Court said that in Batterstar, for instance. If your contention is that PAJA does not do its job, in other words, the 33.3 job of giving effect to the rights to administrative justice, then you must attack the constitutionality of PAJA. So the Constitution is subsidiary. It is there to test the validity of the legislation enacted to give effect to it. The same applies to the Labour Relations Act and other rights in the Bill of Rights. Our first point mentioned in these heads of argument is that we do not concede that this doctrine operates outside legislation giving to effect to rights in the Bill of Rights. Because this is clearly what is a discussion here, and all of these other cases have been about that. So where you rely on a right, we're not dealing here with a rights case. We're dealing here with a power case. The contention is the NDPP lacked the power. Now, the fundamental problem with that is if going back to section 179 and the Justice Haram's dictum affirmed by Justice Nafsa, what they held in effect is that the conferral on the NDPP of the power to prosecute is affected by section 179 sub 2 of the Constitution. It is, in other words, a matter concerning the prosecution authority which is dealt with in section 179 of the Constitution. In this provision, in various places there's a reference to national legislation, but the key here is subsection 7, which says all other matters concerning the prosecuting authority must be determined by national legislation. And as my learned friend Mr. Katz correctly pointed out, those are matters other than the ones already dealt with. So the doctrine of subsidiarity doesn't come into it, because the Constitution itself deals with this issue, and it says other matters must be dealt with in this national legislation, preeminently the National Prosecuting Authority Act. This is, in other words, entirely different to, say, section 33.3 of the Constitution, which says national legislation must be enacted to give effect to the rights in sections 33.1 and 33.2. So with respect, and interesting and beguiling as this point may be, it ultimately falls down on the simple point which I made at the outset. Now, I've unfortunately dwelt a bit on this because this is his big point about 179. This is a matter dealt with by the Constitution itself. The SCA has already said so in terms, twice. We then left with the attacks on non-compliance with the prosecution policy and rationality. And in fairness to Mr. Katz, he conceded, if I understood him correctly, I think he used the word they're intertwined, but these are actually the same point. Mr. Abrams didn't have a special reason for reinstituting the prosecution, and he irrationally thought that he did. It really boils down to that. The governing legal provision, as this court quoted, and we for convenience have requoted it in our heads at paragraph, at footnote 45 at the bottom of page 43, is paragraph 4b of the June 2013 prosecution policy. It's in the bundle as well, and it provides in its relevant part the following, I quote, "People should be able to rely on and accept decisions made by members of the NPA. Normally when a suspect or an accused person is informed that there will not be a prosecution or that charges have been withdrawn, that should be the end of the matter. There may, however, be special reasons why a prosecutor will review a particular case and restart the prosecution. These include, and then the first example is, an indication that the initial decision was clearly wrong and should not be allowed to stand." If one has regard to the relevant parts of Mr. Abrams's affidavit, as this court itself said in its judgment, there was a single reason ultimately why he decided to reinstitute this prosecution, and it's this. The prosecution of Thales would not have been discontinued but for Mr. Mshe's invalid decision to terminate the prosecution against Mr. Zuma in April 2009. In the words of the prosecution policy, Mr. Mshe's decision was found, subsequently, to be clearly wrong, and consequently it should not be allowed to stand. It's as simple as that. Much is made about 9 years in the intervening period, but there we know the NPA was defending that decision.
I thought the court says that on page 63 of the judgment that the National Director of Public Prosecutions assessed the facts, and since the Mashir decision was wrong and irrational, he had no choice but to reinstitute the prosecution. That is in paragraph 172.
I cannot take it any further than that, my lady.
Yeah.
So both of these points are, with respect, hopeless. I would go on to make one concluding submission on this, and that is that my learned friend said, but what about the representations that they made about delay and the prejudice that they would suffer? Well, they fall on the one knee when they concede that the stay of prosecution trial-related prejudice, which was their only permanent stay ground, that must wait for the trial court. And they can't get up from that when one has regard to what is stated in the DA spy tapes case at paragraphs 91 and 94 Roman 8. I apologize, there's a typo in our heads. We said Roman 9, it's Roman 8. And what the court said in no uncertain terms, and the relevant passages are pages 136 and 137 of the bundle, is that in cases like the present, where the charges are very serious, it's a court, not the NPA, dealing with representations, which is the appropriate body to determine whether the extraordinary remedy of a permanent stay of prosecution should be granted. And that's essentially what Mr. Abrams said. He said that we know you're going to be raising this, and it's for the court, not the NPA, to decide that. For instance, in 94 Roman 8, the case law that formed the basis for Mr. Mshe's decision to terminate the prosecution doesn't in fact support it. On the contrary, the cases, including the appeal court decision overlooked by Mr. Mshe, are to the effect that questions of abuse of process in relation to a prosecution should be decided by a trial court and not determined by way of extrajudicial pronouncement. In the earlier passage to 91, it's in the interest of justice at the end of that paragraph. It's in the interest of the NPA, I apologize, accused persons and the public's confidence in the administration of justice that decisions concerning allegations of abuse of process, decisions concerning that be made by the trial court. So with respect, this application too is a hopeless one. The state consequently asks that both applications for leave to appeal be dismissed with costs, including the costs of 2 counsel, and in Mr. Zuma's case that the scale be the costs on the attorney and client scale.
Yes, thank you, Mr. Masud.
My lord, my ladies, in reply, I want us to go back to what this case was really about, because this case was the first time that a court was being asked to examine the conduct, the decisions, the actions of a constitutional body ultimately responsible for prosecutions in South Africa. This is the first time that a court was being asked, in the context of this particular case, not in other cases, in this particular case. The court was being asked to examine what the conduct of the NPA meant when Mr. Nguga made his public announcement, when the NPA made a decision to prosecute and then made a decision not to prosecute. When the NPA, so what the court was being asked was to examine the conduct of the conduct of the NPA from the time that it was known that Mr. Zuma was being investigated for criminal offenses. And the court would have had to look at specific individual decisions, actions of the NPA, and make an assessment of what those actions and those decisions mean in respect of the duties that the NPA has towards the public and towards the accused persons. So what the court had to do was to rigorously examine each decision of the NPA, each action, each conduct of the NPA within the constitutional context that the NPA operates. So the judicial exercise had to be focused on the NPA. What did the NPA do? How did it do what it did? Was that consistent with the policies of the NPA Act and the Constitution itself? That is very important, my lord, my lady, because at base, this is a supreme duty of the NPA. When referred to in Section 32 of the NPA Act, this is what the NPA Act says about the duties of the NPA, and this is important. This is the reason why it is important to test the constitutionality of the conduct of the NPA in respect of those particular events and those decisions and the conduct of the NPA in relation to this case. Section 32 says, a member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith. So when you examine the NPA's conduct from the beginning, from the time that it was announced that Mr. Zuma was being investigated for criminal conduct, you have to ask yourself, has good faith exercise been adopted by the NPA? And then it says in subsection B, subject to the Constitution and the Act, no organ of state and no person or employee or organ of state nor any person shall improperly interfere with, hinder, obstruct the prosecution authority or any member thereof in exercise, carrying out, or performance of his or her powers, duties, and functions. So you're obliged to ask the question, looking at the facts relating to how the NPA has managed this particular case, has there been any improper interference, hindrance, obstruction of the prosecution authority in the conduct of Mr. Zuma? Of more important, I believe, when you evaluate the decisions made, for example, by Mr. Nguga, the decision made by Mr. Advocate Pikoli and Advocate Mshe, you had to examine that against the oath of office that they take. And the oath of office says that they would uphold and protect the Constitution and the fundamental rights entrenched therein, and enforce the law of the Republic without fear, favor, or prejudice. Now, it is plain that there is a duty on the members of the NPA to safeguard not only their independence, to uphold and protect the Constitution and fundamental rights entrenched therein, and enforce the law of the Republic without fear, favor, or prejudice. It is a duty that is given to ensure that just like judges that are sitting today, they are able to carry their constitutional duties efficiently and impartially without fear or prejudice. So in preparing this application for leave to appeal, we looked at the judgment and we said, okay, how has the court dealt with the facts, the key moments of the NPA's conduct in relation to Mr. Zuma's prosecution? Has the court asked itself the question, firstly, what are the constitutional obligations of the NPA? What is it meant to do? What is, when the NPA decides that they're going to prosecute somebody, what are their inviolable constitutional duties? So one of them is that they must prosecute. The prosecution integrity cannot be compromised. You cannot conduct a prosecution in the manner that the manner in which this prosecution of Mr. Zuma has been conducted is not a model of how our prosecution should generally be carried out in the Republic under our Constitution. There is evidence of political interference. Whatever one says, it cannot be ignored in an application for permanent stay, which, with respect to my learned friend, say arguments relating to that aspect, when that argument was made before Justice Nicholson and they upheld the argument, it was easy for this court to actually validate that point of political interference, because where is the evidence from? The NPA itself.
Mr. Masuka, sorry to interrupt you, but can you just tell me, after the decision of the Supreme Court of Appeal, what remained of Justice Nicholson's judgment?
No, I know your position on the issue of Justice Nicholson. Can I just make the point about what evidence you had of political interference when you considered this case? The simple evidence you had was the affidavit of Mr. Hofmeyr. The affidavit of the NPA itself was before the court. So we can debate about what Nicholson's findings said and did not say. We did say that there was political interference. The Supreme Court of Appeal said there is no evidence of that. But this court had that evidence. And that is what, if one reads the affidavit of the NPA, which is deposed to by Mr. Hofmeyr, that is uncontested. They've not withdrawn that affidavit. It has not been withdrawn by the NPA. Still stands an affidavit before a court. And so when a court decides to deal with a permanent stay application, it is enjoined to look at that affidavit and say to itself, does this affidavit demonstrate a model of how the NPA ought to conduct itself when it prosecutes an accused person under our Constitution? And the answer, and that must be done with reference to the Constitution, to the NPA Act, and the NPA Code of Conduct, and the directives that govern the NPA. So had the court looked at that affidavit of Hofmeyr, they would have said there is evidence that from the NPA itself, assessing its own conduct, that they have handled Mr. Zuma's prosecution in a manner that is less than satisfactory. So what the court now has are two affidavits. One affidavit by Mr. Hofmeyr saying there was political interference, everything was wrong with how we dealt with this case. These are the key players in the prosecution authority. These people who have deposed the affidavits are key functionaries in the institution. And then Mr. Downer deposes to an affidavit saying nothing happened, for which you could infer political interference. The court then must ask itself, there are two affidavits from the same institution explaining how they've managed the prosecution of Mr. Zuma, and ask itself, does this conduct rise to the, does this conduct meet the constitutional test that the NPA ought to satisfy in order to conduct a constitutionally compliant prosecution? So, in a way, what this case really was about was for this court to look at, from the time that it was announced that there's prima facie evidence of criminal wrongdoing against Mr. Zuma, to the time that the Supreme Court of Appeal said the decision to terminate his prosecution was wrong. The court ought to be focused mainly on the NPA in respect of what the Constitution says about its role, what binds the NPA, and assess that and determine whether, measured against those principles, the NPA had achieved a constitutional credibility to conduct a prosecution that is valid is against Mr. Zuma. So, and why? Because the entire case that Mr. Zuma presents before the court is that my rights have been violated. My constitutional rights have been violated. And so when you assess whether or not his constitutional rights have been violated, you have to be rigorous in looking at what the NPA itself did, not what Mr. Zuma did. And we see the insults that Mr. Zuma gets being heaped on calling his legitimate exercise of constitutional right as Stalin grant. But our constitution allows that Mr. Zuma makes a choice to exercise those rights. So when he legitimately approaches the court and says to the court, I was told way back that there is a prima facie case against me. Up to today, I've not been tried. And if you look at the slew of misconduct involving the NPA, which includes the judgment of Mr. Nafsa, Justice Nafsa, who says about the NPA's presentation of an affidavit, it's very unsatisfactory for the NPA to conduct itself like that. You present an affidavit before a court explaining your decision to terminate a prosecution. And that is rejected by the courts. That should weigh very heavily on a court that is operating within the norms, the values of our constitution. It should be sensitive to the fact that an institution with as much power as the NPA has must perform its functions with absolute rigor, complete compliance with the Constitution. So what are the implications of this judgment that we are seeking leave to appeal? In essence, the court finds that the NPA has always acted reasonably and in compliance with their constitutional duties. We submit another court examining that, examining firstly what is contained in the affidavit of Mr. Hofmeyer, what Mr. Mshe himself says about the conduct of the NPA, examining the remarks that were made by Justice Msimang, the late Justice Msimang, when he struck off the matter from the roll. Because when he struck off the matter from the roll, he just didn't say about the NPA that they were delaying. He did speak about the prejudice of that delay to Mr. Zuma. So we already have judicial findings, already telegraphing to the NPA that if you continue behaving like this, there is prejudice that the accused person faces. And this court should have had regards to that. The court should have had regards to a constitutional institution that has examined the conduct of the NPA and come to the conclusion that that conduct violated Mr. Zuma's rights, which is the public protector. That report has never been reviewed or set aside by the NPA. It stands as it is. It stands as testimony that Mr. Zuma's rights were violated when the NPA was hanging his prosecution. So, Your Ladyship, Justice Poyo asked my learned friend a pertinent question. Would another court, looking at the permanent stay application, not looking at whether or not the NPA's decision to terminate proceedings against Mr. Zuma was valid or lawful, would another court, looking at the NPA's overall conduct from the time it announced its investigation to the time it was told you are wrong to have terminated these proceedings, does that conduct, looked within the prisms of the Constitution, rise to meet the constitutional test that is established for the NPA? And the answer would be most likely another court would come to the conclusion that the NPA's conduct taken in its totality is inimical to its duties under the Constitution. So this, and my learned friend, my leader this morning when I addressed the court, he did indicate that in essence, what would concern a higher court are questions as follows. Did the NPA, taking specific actions and decisions and assessing the overall conduct of the NPA, comply with their constitutional duties? A higher court would consider, for example, whether it is consistent with the constitutional culture of that governs prosecutors. For a prosecutor to seek political assistance by calling a politician and asking whether or not to prosecute and when, and how that would achieve a political outcome. When you're looking at when you're looking at permanent stay of prosecution, it's important that you examine that particular aspect and determine it in relation to how it affects the constitutional credibility of that prosecution. The interference with the prosecution decision by a former prosecutor, one must ask, is that okay in terms of our Constitution? More fundamentally, we're told that there were a clean crop of prosecutors who were constantly telling the leadership of the NPA to prosecute Mr. Zuma from the time that Mr. Ngoga made the decision not to prosecute. There's a clean crop of prosecutors who constantly said, please prosecute, please prosecute, please prosecute. We are ready to go. But they were constantly told, no, we're not going ahead. Would that be consistent with the duties of a prosecutor? Conducting a prosecution as a proxy, testing the waters to see whether the case that's coming, the bigger fish, whether the bigger fish can be caught. My learned friend did not address that issue with reference to what's in the prosecution memo when the judgment of Sheikh was handed down, and he was asked to give, and Mr. Billy Downer was asked to provide a memo so that Mr. Pikoli could decide how to deal with the matter. I want to refer the court to an annexure which is in the founding papers. If the court just bears with me. Oh, where's the paper? I'd refer the court to annexure JZ5 on page 2208.
Anisha?
Annexure JZ5. I think it's JZ5. But let me just be sure, my lady. It's JZ5, but it's on page. It starts on page 2207. I beg your pardon. My attorney says it's JZ528. I'm not sure, but it's on page 2207. And this is a memorandum that was prepared by Mr. Downer. And this is how one assesses what was in the mind of a prosecutor when they were strategizing around prosecuting Mr. Zuma. He says in a confidential memorandum, this report has been compiled at the request of the National Director of the Prosecution as conveyed to us on 8 May 2005. We have been requested to provide a report on the prospects of a successful prosecution of Deputy President Jacob Zuma in light of the successful prosecution of his financial advisor, Shapia Sheikh, and various of his companies on charges of corruption. We have been asked to pay particular attention to issues of admissibility of evidence and other practical difficulties that may have been encountered in such prosecution. We have been requested to advise on any further investigation required. So what the prosecutors are told, please give advice on what chances we have in light of the outcome of that particular case. To suggest that the outcome of Mr. Sheikh is of no moment in as far as the prosecution of Mr. Zuma is concerned is not entirely correct. It's simply naive. So in paragraph 7 of the memorandum, this is what the prosecutors say. However, on the evidence presented in the Sheikh case, the court found that the state had proven beyond a reasonable doubt, and then they cite the evidence that was proven in that case. They are advising on the prosecution of Mr. Zuma, but with reference to what evidence was dealt with in the Sheikh trial, and how that would assist them in future when they have to decide to deal with the case of Mr. Zuma. My lord and my ladies, this memorandum is very critical to the debate that you had with my learned friend, my learned senior, and that you had with my learned friend for the NPA, in looking at what we refer to as trial by proxy or dry run, because it demonstrates that dry run that the prosecution was engaged in. Prosecute Mr. Sheikh, see how it works, and then when it works, assess your prospects of success, and then prosecute. Ask yourself whether that is an appropriate use of prosecutorial powers. The conclusion would be, it in fact undermines Section 9(1) of the Constitution, which specifically provides that everyone is equal before the law. So what then happens is that Mr. Zuma watches a trial that names him, goes on, he watches it. His name is mentioned. The nation has been told prima facie evidence exists. They run the trial, they are successful. When they are successful, then they write this memorandum, which memorandum says, yes, you will be successful because we've now gotten a light, we now have found that we now have judgments that now deal with the evidence that would be of assistance to us when we go after Mr. Zuma. So there are numerous examples that one can get. If I, at the same time that my learned friend had this morning, I would take the court through it. And what I can say is that there are impeccable sources from which one could assess the NPA's conduct. Considered unlawfulness by the NPA. One of them is the judgment of the ACA. But the other is the public protector. The other is Sumar. The other one is, I know there is a story about Nicholson. They don't particularly like Nicholson's judgment. But what is very important about that judgment is that it was rigorous in examining the conduct of the NPA vis-a-vis their constitutional responsibilities. My learned friend for the NPA suggested that we had not raised trial-related prejudice. That's simply incorrect. I would simply leave it there because that is not exactly the position of our case. Our case did raise trial-related prejudice, including the fact that there had been a trial run of Mr. Sheikh, a determination of evidence that would be relevant for Mr. Zuma, which now has to be, which would in fact be important. In fact, this memorandum, as I point out, it deals with the admissibility of documents, and one must just have a look at it to appreciate how the NPA was thinking, how they believed that they would borrow from the Sheikh trial evidence that they would use in the case of Mr. Zuma. And it's not defense with respect to say, well, they would have to start afresh. There are already judicial pronouncements that are made in relation to the legal issues that are involved there, which are binding on Mr. Zuma and the NPA. And Mr. Zuma had no chance to actually deal with those legal issues. my lord, my ladies, you would have to just another court looking at the conduct that gave rise to the Browse Mall investigation, looking at McCarthy's conduct, looking at just how the NPA managed this particular case. It did not meet the constitutional test. And with respect, we go back to what the courts, what the courts have said, what the Constitutional Court has said about institutions that are in the position of the NPA. And we did refer in our heads of arguments in our previous case to the Nkandla judgment, where it was pointed out that an organ of state with weighty constitutional responsibilities ought to operate in a way that gives integrity to the constitutional functions that they face. In the investigative directorate serious offences and others versus Wundai case, which we referred to in our heads, we did refer to what the Constitutional Court says in paragraph 21 and 24, where it says all lawmaking authority must be exercised in accordance with the Constitution. And all that we say, my lord, my lady, is that this case is significant because on it, the NPA will know whether their conduct can be condoned at all by the courts, whether the various decisions that they took relating to the prosecution of the Zuma warrant judicial condonation. It is another court would be outraged by how the NPA has conducted itself, as the SCA was when it ruled that the termination of the prosecution was not in accordance with the powers of the NPA. So we ask that you put a significant mileage on the fact that, on the nature of the case that we're bringing before you. It is an application for a permanent stay. It implicates the conduct of the NPA, which has very weighty constitutional responsibilities that implicate our constitutional rights. There are specific claims that are made by Mr. Zuma relating to how the NPA's conduct has violated his own rights. Another court should be given an opportunity, the higher court should be given an opportunity to look at your judgment and to determine, in light of your judgment, whether it is correct to let it go. Basically, let it go because he must have his day in court. We submit that a court examining the totality of facts that underpin the NPA's conduct would find that it was very unsatisfactory that the matter was dealt with in this way. May ultimately say that Mr. Zuma is not successful, but it is very helpful for this court to allow another court to deal with the issues that relate to the NPA's conduct. As I say, one of the most important institutions of our legal system, and to determine whether or not in future we have an NPA which we can trust with the constitutional powers that it has, and we have to do that in relation to how they have managed this particular case. As I said, and then of course, a constant refrain in the NPA's case is that, which is borrowed from the Supreme Court of Appeals finding, that there was within the NPA a group of people who preserved the integrity of the investigation. There were others who did not preserve the integrity of the investigation. And so it is argued, you've got to look at those who preserved the integrity of the investigation. Billy Downer being one of them. Constant, prosecute Mr. Zuma, constantly overruled until the SA itself had to say, no, please prosecute Mr. Zuma. When the NPA says that, it does not say Mr. Zuma's rights to bring an application as this one is essentially closed, and he ought to walk into a trial court and be prosecuted. My Lord, my Lady, I conclude by referring to the Sanderson case on the costs, which we say that at the very least another court would find that these proceedings did not justify the cost orders that that this honorable court granted. In paragraph 43 of the Sanderson case, this is what the court said. This judgment cannot conclude without saying something about costs. The dismissal of the appellant's application in the High Court carried with it an adverse order for costs, as in this one. That was in conformity with long-established practice in that court, even in cases such as this, where the relief sought is tied with a criminal case. But in paragraph 44, which we quote in our heads of arguments, the court says, and I read from the second sentence, ordinarily the dismissal of a claim such as this in the High Court should not carry an adverse cost order. The High Court might actually follow the same principle that was enunciated here in the Sanderson case. We accept that you were asked specifically to deal with the issue of cost, and you dealt with them in accordance with the discretion you have. But we have a principle in Sanderson which you in fact referred to in assessing the issue of permanent stay. The only issue that you did not deal with was whether or not a cost order would be justified under these circumstances. In fact, with respect, a cost order would be entirely oppressive in light of what the NPA says Mr. Zuma's prosecution has cost the state, and so would submit that where a party is fighting for is asserting constitutional rights, a court should not be hasty to reward the prosecution with cost orders, the same prosecution that would then be obliged to carry to conduct the criminal prosecution should the matter get to that point, which we hope it doesn't. Honorable Justices, those are my submissions.
Thank you.
Thank you. I'm going to make 4 sharp submissions in reply. In saying what I'm going to say, we stand by all the submissions that we made in our heads of argument and in oral argument this morning, including in particular the prosecution policy points and the rationality point. I won't say anything about those aspects in this reply, but what I will say as an introduction to the points is that having read Mr. Brayton, I said, having heard him, he makes out our case for us on the application for leave to appeal in respect of the powers point. Let me say why. I listened very carefully, and quite apart from him not taking up my invitation concerning section 22 of the NPA Act, he did not mention it at all. He did not take up the invitation, he did not defend this court so-called interpretation of 179.2 to be done with the aid of the NPA Act. We submit that in and of itself, this is the first point that we submit, that in and of itself is a reason, which I'm going to come to why, to grant leave to appeal on the strength of paragraph 57 of NAFSA ADPP's judgment. And I'll come to why, and I'll read it to the court. That's the first proposition. So we submit that this court, in applying the four trite propositions, none of which my learned friend suggested were wrong. He suggested that the consequences and the various ideas that flowed from them weren't that which we submitted, but he didn't take issue with the substance of the four trite propositions, Constitutional Law 101, etc. The question of Berg River, Liebenberg, the question of the non-availability of legislation to interpret the constitutional provision, or the principle in my vote counts. Whether it applies in this case was a different issue. So, but his decision not to deal with the NPA is going to, we would submit, force this court to consider what NAFSA ADB said in paragraph 57. The second proposition is this. In defending the Abrams invocation of 179.2, he relied on the two judgments of the SCA, and he said, why would this court go groundhogging and send it back to the SCA to decide that issue again? But we need, in order to come to that understanding of Groundhog Day, understand what were the courts concerned with in those cases. In the first case, Harum's DP dealt with the question of an appeal against Nicholson J's upholding a challenge by Mr. Zuma to the institution of prosecution against him. The case did not deal with whether or not 179.2 granted and would be entitled to be relied upon by the NDPP in the institution of prosecution. That was not what the case was about. Number two, the second case that he refers to is the NAFSA ADP's judgment in Zuma versus DA. And the court importantly will remember that the High Court set aside Advocate Mshe's decision. What then happened was Zuma applied for leave to appeal and it was rejected. Mr. Zuma then petitioned the SCA. And what the SCA did was it said, we're not granting you leave to appeal yet. Come and have your hearing and we'll consider the leave to appeal in the hearing. And may I read paragraph 57, and it's important, and we would submit that it's determinative of how this court does make its decision. It's a point that I made before lunch, and I reiterate, this is crucial. This is what, it's on page 133 of the State's bundle, and we would ask that the court turn to it, because it's crucial. This paragraph determines this application. What NAFSA ADP says is, the two applications for leave to appeal, as stated in the beginning, were referred to for oral argument in terms of section 8 of the provision, in terms of the provision of section 17.2D of the Superior Courts Act, and there's a quote from 17.1A, which provides for, and we all know what the two legs are, the two possible jurisdictional facts, reasonable prospects and some other compelling reason. And what NAFSA ADP says is this: the present case raises issues of public importance. It's a point that I made before lunch. Who has the power to institute a prosecution? As previously mentioned, it is part of a long-standing litigation saga that involved the President of the Republic of South Africa, full stop. It concerns the office of the NDPP and its powers and obligations. Furthermore, the conduct of prosecutors within the NBA falls to be considered. For these reasons, and we emphasize, for these reasons, apart from the question of prospects of success, leave should be granted in terms of 17.1A little 2. That is the other compelling reason. So we submit, just like that case, where the issue is of public importance, dealing with the powers and obligations of the NDPP, long-standing litigation saga, the conduct of prosecutors within the NPA falls to be considered. Those reasons in and of themselves, according to NAFSA ADPP, fall within the second leg of the 17.1 determination, other compelling reasons. That sentence in and of itself, we would submit how this court should determine this Tully's application for leave to appeal. The third basket that I'm going to refer to, subsidiarity. Mr. Breitenbach accepted, as he had to, that subsidiarity applies to rights in the Bill of Rights. But he said, that doesn't mean, he used the words interesting and beguiling argument of ours, that it applies to powers. Why not? There's never been a case that says that subsidiarity doesn't apply to powers, and we submit, just like rights, powers are subject to that subsidiarity principle. And if we are wrong, the SCA or the Constitutional Court will tell us. But it's not for Mr. Breitenbach to say there's no possibility that subsidiarity does not apply to powers, because there is no authority and there's no suggestion in any academic articles anywhere that the principle of subsidiarity doesn't apply to the question of powers. And that in and of itself, we would submit, is a compelling reason for this court to give leave, because implicit in Mr. Breitenbach's stance is that if subsidiarity does apply to powers, then we win, subject to the Groundhog Day point, which is a no-brainer, because Haram's DP and NAFSA ADP didn't deal with the question that's now at stake in this case. So how could it ever not be, we would submit, not a compelling reason for the kinds of issues that are raised in Tully's review application on the powers point at least, to be determined by the appellate division, by the SCA stroke the Constitutional Court, an appellate court. And we would submit, for that reason alone, this needs to go higher. And we would submit that if we take that basket of acceptance by the NPA of the 4 trite propositions, Constitutional Law 101, and one determines, do they apply to this case? Those are legal issues. They're not factual. There's no factual dispute about what happened here. And a legal issue of the kind that we have raised is the kind that NAFSA, ADP, for the 5 judges of the SCA in a similar case have said they are compelling reasons. My juniors reminds me that I must remind the court that we do not abandon prosecution policy and rationality. We've heard what Mr. Breitenbach says about those points. We disagree. And your ladyship, Justice Steyn, I think, said something along, and correct me if I'm wrong if I heard the interchange, that when, in October 2017, the SCA set aside the original share withdrawal, it then became incumbent, if I understood your ladyship.
I refer to the judgment, Mr. Katz.
Yes.
Delivered by this court, nothing else.
Your judgment.
Our judgment.
Yes.
Our judgment.
Sorry, which paragraph?
Yes,
And I can't
judgment.
find the paragraph that you referred to. I thought it was 172, I thought you said. And then I looked at 172 and I didn't quite.
Page 63 of the judgment. It says the NDPP assessed the facts, and since Moshe's decision was wrong and irrational, he had no choice but to reinstitute the prosecution. I was simply quoting the
That's
judgment.
correct. Yeah, no, that's correct. That point in and of itself, we would submit, is a point that requires consideration by the appellate courts, in the sense that once the October 2017 SCA decision was made, it doesn't follow like night follows day that there needed to be a consideration of the prosecution of colours. That's the simple proposition. It's on the pleadings, it's in our heads of argument, every case. And let me say why I say that. Because Mr. Breitenbach said, in defence against a point made by Sikakani, this is what he said, and I've written down what he said, there is no principle in South African law that co-accused need to be tried together. Then he said, the state must live with the consequences of not prosecuting Zuma and Sheikh together. And we submit similarly, the state must live with the prosecution decision in 2009 to withdraw against Tully's because it had withdrawn against Mr. Zuma unlawfully, as it turned out 9 years later. So we would submit that this is clearly a case that calls for an appellate court to consider the legal issues that we've raised. They are serious, they are important, and they are of massive public importance, and they have not been decided by the upper courts yet, as it pleases the court.
Yes, thank you. Thank you to all of you. The judgment will be handed down on 29 November 2019 at 10 o'clock. Court will adjourn.
Understand this right now. The Weighty director will get the security. 20 minutes next week. Taban Masubi.
Kwenziwa njani la? Zona nditrol ngifuni emvini bazobeke ngama 5. Ndabeke ndingabalandela ngishini bench. Then yabanike lento ekasteng. Ngicela ungithathele ama-glassing. Khona la phansi ke ngayazi ukuthi yaba. Okay, ngiyenzela. Ibhala ama-authorities. Ngifuna nditrol.
We're gonna go because we need to make she just I'll also check. We can choose
I'm cleaning a report on Monday, Tuesday, and Wednesday.
What about guys doing what?
Sprint, my man.
But
Did he talk to yourself?
I will remember that. I'll remember what it did today. Which is to just go on and on when you know that I'm going to.
No, I tried to as much as I could. He's not guilty.
It's at 6.
And it's interesting, yeah.
Monday, Tuesday, Wednesday. 3 or 4 in Kosovo. So you're going there to the temple. Quite extreme program. Where's the so that way, I'll come settle those things.
I'll see you.
Oh my goodness. Crazy. They just closed my
we just finished court on your office. I just thought it was fire.
Hello, 1, 2, 3.
Okay.
Hello, Derek, 1, 2, 3, 4. Derek, 1, 2, 3, 4. Testing 1, 2, 3, 4. Hello, Derek, ABCD. Testing 1, 2, 1, 2, 1, 2. Hello, Derek. Hello. You got it? Okay, thanks. I think he's gonna go with his phone.
Yeah, no, nakhona futhi hayi ngathi bathi ngeke
Are you going to use your,
basayidinga ngoba.
are you going to use IP? You need IP or are you going to use your
No,
phone?
I won't be on camera now.
Huh?
I'll only do what do you call
Coffee.
this? Fongoni. I'll only do this thing Fongoni.
Huh?
This short look like Fongoni.
No.
Um,
Hybrid.
No, because it's
Oh, not us.
Oh.
English have a
Yeah,
problem.
word.
No, so
Word.
I'm still on it.
Oh, okay.
I'm gonna record it. Look like.
I already started at this morning. Oh, can't we put...
Oh yes, but I wasn't here. Fiorella, nice to meet you.
Oh, you just wanted to squeeze it. That's what you wanted.
Griffith. Hey, what are you doing here, man? Hey, Andrew, hey.
I'm not